if I could have your attention. For those who I've not met, my name is Phil Weiser, and I am the Dean here at Colorado Law, and I have the distinct pleasure of introducing today's Coen lecturer. The lecture has gone on for quite some time, and we have quite the distinguished group of past presenters. We also have a very distinguished audience here, including the Chief Justice of the Colorado Supreme Court, Mike Bender, one of our own, and a number of members of our faculty and community. We really appreciate you all coming together. This is a great opportunity for us to exchange ideas and live in the world of ideas. It was not timed to be during the Conference on World Affairs, but it turned out to be during the conference. So for those who've taken any of the conference, you're hopefully primed for a real intellectual treat. For those who haven't followed Jeff Stone's career, you wouldn't know that he was Dean of Chicago, Provost of Chicago, and made some interesting and important decisions during that time, including, as Larry Lessig tells, how to configure the internet on the Chicago campus, and to do so in a way that was maximizing free speech and anonymous speech by allowing people to use the internet anonymously. Is that still the case in Chicago? Yes. Whereas other schools like Harvard, you had to sign on and you would track whatever you did. This, of course, is great as the Paul Ohm, our privacy scholar who scared the whole faculty this week by talking about how we're all monitored constantly when we're on the internet, apparently not at Chicago. So you can keep that in mind next time you're visiting there, and that was due to his decisions as provost. As an academic, he is one of the nation's premier First Amendment scholars. And his recent book, focusing on wartime and the Constitution, really sharply brings those issues front and center. And today's project is relevant. I think you picked the topic before the Affordable Care Act really sharpened this issue. But for those who missed the New York Times this week, Paul Carrington talks about judicial activism and the need to curb it. His remedy is term limits for judges, which was the Conference on World Affairs topic that I had the pleasure of moderating at lunch today. I don't know if that's a congenial solution for Professor Stone, but he is here to talk about the rise of judicial activism and what we might think about it and do about it. So without further ado, Professor Jeff Stone.
Thank you, Phil. I'm delighted to be here. At the outset, I'm going to have to just warn you that I have a head cold. And those of you who are teachers or lawyers know that when you have to speak or teach or law and you don't feel well, it can sometimes be a little bit frustrating. Your head gets all foggy and it's hard to think straight and so on. So you'll have to bear with me if I cough and sneeze and do any of that stuff, but I'll try not to. I took a lot of medication, which also is a problem. And actually, whenever I feel like this, I remember when I was a kid, I had a friend, Steve, who was, frankly, a lot slower than the rest of us. And nothing clinical. Steve's had a very fine career. He's made a lot of money, as a matter of fact, which I still don't understand. But I used to wonder about Steve in terms of, what was it like to be this guy who always seemed, about 2/3 the way behind the rest of us when it came to thinking or arguing or reading or math or anything. And one day I had this terrible cold, like what I have now, and I remember looking over at Steve and thinking, damn, that's what it's like to be Steve. Okay, so fast forward 15 years, and I was a law clerk to Justice Brennan on the Supreme Court. And one day I was in chambers with the justice, and he had an awful cold, and he was coughing and sneezing, and I was meeting with him about a case. It was actually Roe v. Wade, as a matter of fact. And I was thinking, poor guy, he feels lousy. And then it occurred to me that he must be sitting there thinking, this is what it must be like to go through life as Jeff Stone. So what goes around comes around. Okay, so what I want to talk about today is judicial activism and the Supreme Court. And it's true, as Phil said, that the current debate about the Affordable Care Act makes that a particularly immediate issue. But it wasn't that act, that case, that triggered my thinking about this question. What really has had me thinking about it for a long time is the fact that conservatives, of which I'm not one, have come to dominate and control the discourse about the proper role of the judiciary over the last 40 years. And that's a source of continuing frustration and puzzlement to me. And I've been thinking about what that all is, how it came about, and how does one try to respond to that and ultimately to reverse it. So as I said, what I want to talk about is judicial activism. So what I mean by judicial activism, just to be clear, is in contrast, of course, to judicial restraint. Judicial restraint means basically, in simple terms, when a judge applying the Constitution gives deference to the judgment of the elected branches of government. And it doesn't mean that anything goes. It does mean that the legislation that's challenged as unconstitutional has to be non-arbitrary and reasonable. But the judgment as to whether it's reasonable is one that's made with respect for their coordinate branch of government. Judicial activism, on the other hand, involves a very different presumption. The presumption of judicial activism is that the judge should not defer to the judgment of the elected branches of government, that the judge should be willing aggressively to second-guess those judgments in interpreting and applying the terms of the Constitution, and be willing to set those judgments aside if the judge feels that the government has not demonstrated to a reasonably high degree of persuasiveness the constitutionality of the legislation at issue. Now, obviously, the world doesn't fit neatly within only those two categories, but for my purposes, they suffice to sort of lay the groundwork. So the first thing to note is that a part of the mythology that conservatives created was that judicial activism is liberal and judicial restraint is conservative. And this mythology developed primarily in the end years of the Warren Court, when conservatives attacked the liberal Warren Court as activist and associated liberalism with activism. But in fact, historically, there is no connection between liberalism and activism or conservative and activism. Liberalism is simply a methodology of approaching constitutional interpretation. Activism is just an approach to constitutional interpretation, and it can be used and has been used historically by conservatives and liberals alike. For example, in the early years of the 20th century, during the Lochner era, it was conservative justices who used a rather creative interpretation of a non-existent liberty of contract in order to invalidate a wide range of progressive legislation involving maximum hours and minimum wages and protective legislation for workers and so on. And in invalidating that legislation, those justices gave no deference to the judgments of the elected branches, but instead engaged in a conventional form of judicial activism, a form of activism that was decried by progressives, by liberals, by individuals like Brandeis and Frankfurter, who attacked the Supreme Court and said the appropriate stance of justices is one of judicial restraint, and basically associated conservatives with judicial activism. And indeed, for much of the career of those individuals from that generation, the liberals, the progressives, adhered to the view, including Frankfurter, for example, that judges should approach constitutional law from a very restrained standpoint. In the Warren era, it was essentially liberal justices, politically liberal justices, who employed judicial activism in a way that raised the ire of conservatives, who basically claimed that liberals were activists and conservatives were passive. and that restraint was the right approach. So what conservatives have done is basically to assert that the proper role of constitutional interpretation is restrained, it's passive, it does not make up the Constitution for political or ideological reasons. It strictly construes the Constitution. It follows the originalist, it follows the text, a variety of cliches. It calls balls and strikes, most of which have no meaning, but which have clearly captured the public imagination as the appropriate means of constitutional interpretation. And what I want to do is debunk that set of myths. So a good place to begin is with the original conservative attack on judicial activism in the late 60s, when conservatives like Richard Nixon, in running for president in 68, ran in part against the Supreme Court of the United States, against the Warren Court, on the ground that those justices were run-amok activists. That the attack was that those justices essentially substituted their own personal predilections, values, preferences, and judgments of the good society for those of the elected branches of government and simply imposed them on the rest of the society in the guise of constitutional interpretation, and that all of this was therefore illegitimate. And what we needed was judicial restraint. Judicial restraint was the proper means of constitutional interpretation. It was what conservatives would do. And in fact, true to that, Nixon nominated to the court Earl Warren and Harry Blackmun and Lewis Powell and William Rehnquist, all of whom were, despite their evolution over the years in different ways and their occasional departures from that approach to constitutional interpretation, were for the most part justices who believed in the principle of judicial restraint. And that was their view of conservatism. It was a withdrawing from what they saw as the activism of the Warren Court. And the role those justices took for themselves, their conservatism, consisted primarily of staying their hand and not reaching out to invalidate things, or withdrawing some of the implications of the Warren Court decisions, but it was not, for the most part, activist. They were consistent with what Nixon wanted them to be, at least in the early years of their tenure. But there was a problem with that approach. And the problem with that approach was that judicial restraint across the board may have the virtue of a type of neutrality, but it has the lack of virtue of abdicating a fundamental responsibility that judges were meant to have, intended to have, in our constitutional scheme. The framers of the Constitution were acutely aware of the risks of majoritarian abuse. And they looked to the judges with life tenure, insulated from the political process, to play an essential role in checking those abuses. So this was very evident, for example, when the issue of the Bill of Rights arose. The original Constitution, as you know, did not contain a Bill of Rights. And when the Constitution was put forth, this led to a wide range of objections about the absence of a Bill of Rights. And one of the defenses that was made by those who drafted the original Constitution was that it would be pointless to have a Bill of Rights in the Constitution. Because the truth is, majorities would do whatever they wanted to do. And listing a bunch of rights really didn't make any sense. Rights were necessary, they argued, against a monarch. The citizens needed to protect themselves against a monarch. And a Bill of Rights was critical in an environment where you were dealing with a monarchy. But in a democracy, who do you need to protect yourself against? right? Against yourself? That doesn't make any sense. So their argument was that, A, you didn't need a Bill of Rights, because you didn't have somebody running the government who wasn't you. And second, that even if you had a Bill of Rights listed in the Constitution, it would serve no purpose. That majorities would just do what they wanted to do anyway and say they had acted in a manner that was consistent with the Bill of Rights. So it would accomplish nothing. And indeed, when Jefferson received his copy of the Constitution, he was off in Paris at the time, he liked the Constitution, but he wrote back to Madison and he said, what were you guys thinking? There's no Bill of Rights in here. And Madison wrote back and he said basically what I just said. He said it would be pointless. Right? These would be parchment barriers, in his words. That they would not really limit government at all, and it would just lead to a feeling of hypocrisy, so we're better off without them. And Jefferson wrote back, what about courts? What about independent tribunals of justice who were charged with the responsibility of enforcing against majorities these guarantees? And Madison was taken with this argument, as were most of the other framers. And indeed, when Madison presented the Bill of Rights to the first Congress, he expressly addressed this concern, which he himself had embraced, and said that the protectors of these Bill of Rights will be the courts. That these independent tribunals of justice will guard the rights of individuals against the dysfunctions that can arise in a majoritarian political process. And Alexander Hamilton made a similar argument to the effect that in a constitutional system, democracies can act in ways that are unwise and inappropriate, that they can disadvantage those who lack access to the political process for a variety of reasons, and courts are necessary to step in when those dysfunctions occur. So the problem with judicial restraint across the board was that it would abdicate, for all practical purposes, a fundamental responsibility that the Constitution and the framers of the Constitution intended courts to exercise. Now, this posed a dilemma for conservatives who were adhering to this idea of judicial restraint. And a group of conservatives involved Ed Meese and Robert Bork, Antonin Scalia, basically came up with the idea of the modern version of originalism as a solution to the conundrum. They accepted the fact that judicial restraint was generally good, that they did not want judges going off and substituting their own personal predilections for the judgments of the elected branches of government whenever they felt like it. Judges needed to be constrained. But they also recognized that the Constitution assumed that judges would play a serious role in enforcing constitutional guarantees in appropriate circumstances. And giving up that responsibility, they understood, was unacceptable and unprincipled. So to their credit, they came up with the idea of originalism as what they hoped would be a solution to the conundrum. And the idea was that, okay, judges will only invalidate laws that the framers or the framing generation of any given provision of the Constitution understood and intended to be unconstitutional. That is, the justices would stand in the shoes of those who framed the particular provisions of the Constitution and of the generation that ratified the particular constitutional provision, and they would act as their agents. And they would be activists, when necessary, to achieve what the framers specifically intended and understood that they were trying to achieve. But beyond that, judicial restraint was the only permissible approach. And this was a well-meaning and sensible, or at least at first glance, sensible approach to the problem. Unfortunately, originalism as a methodology has at least two grievous failings. The first one is that, in most interesting cases, the history turns out to be ambiguous. This is not surprising. The framers of broad provisions like no state shall deny any person the equal protection of the laws, or Congress shall make no law abridging the freedom of speech, or no state shall deprive any person of life, liberty, or property without due process of law. They were not thinking about specific issues in terms of the possible meaning of these broad aspirational phrases when they were drafting this language. They'd never lived at the time the Bill of Rights was adopted in a world with a judicially enforceable Bill of Rights. They didn't know what the freedom of speech was. They didn't know whether it protected what we now call obscenity, or in what circumstances it allowed libel actions, or whether it gave people a right to march in demonstrations that would be somewhat disruptive. They'd never heard of things like clear and present danger. They just knew the freedom of speech was a good thing. And so the problem is when you begin trying to look into the history, what you almost always find in actual cases is that there is either no history that's really very helpful, or to the extent there is history, it's conflicting. And indeed, historians, on almost any issue that the Supreme Court has ever addressed, where originalism was seen to be critical to the possible outcome, have basically divided themselves on what they thought the actual original understanding of the various provisions was. And so what happens then? Right? The justices themselves, of course, are not historians, so they're not very sophisticated in their use of the historical materials. And even if they were, for the most part, they wouldn't find any clean answers. So what then do they tend to do? Well, not surprisingly, what they tend to do is to basically look at this vague data and then say to themselves, well, let's see, the framers were reasonable people. Right? I'm a reasonable people. If I was a framer, this is what I would have understood this provision to mean. And lo and behold, originalism leads to a result which just happens to comport with the personal values of the justice applying originalism. And indeed, if you doubt this, look at the decisions in which the court has, or individual justices have invoked originalism, and knowing nothing yourself about the history, ask how you think they would vote based upon what you think to be their basic ideologies and political preferences. And I guarantee you that close to 100% of the time, they will wind up in the same place. That basically the originalism in any of these difficult cases is a cover. Whether it's a cynical cover, I kind of doubt. I think it's a more sincere cover, but it's basically a cover for the ideological views and preferences of the justices. So the first problem with originalism is that when it actually matters, it turns out that it doesn't control very much, and it certainly doesn't control the inclination of justices that has been thought to be worrisome, which is the substitution of their values for those of the elected branches. But worse, it winds up being intellectually dishonest. Okay, the second problem with originalism, it really derives from a broader point. Justice Scalia was in Chicago, and he and I addressed this issue. And Scalia's response to the first point I made was, well, yes, it's true. You're right. It's hard to do that history. It's difficult material. You just do the best you can. Right? We just do the best we can. Well, again, the problem with that is the best we can turns out to be almost 100% ideologically predictable. But put that aside. He says, but the real virtue of originalism, it takes off the table all sorts of stuff. right? It basically constrains the courts to a much narrower set of issues than would otherwise be tempting to the justices. So abortion, certainly no framer of any provision of the Constitution thought that abortion was rendered unconstitutional. Death penalty? Of course the framers didn't think the death penalty was unconstitutional. In the very terms of the Bill of Rights, they talked about depriving any person of life without due process of law. Therefore, they had due process of law. They could be deprived of life. Women in the Equal Protection Clause, that's not what the framers of the Equal Protection Clause had in mind, and so on. So Scalia's view is even if originalism is problematic in the way I've described, it at least has the virtue of narrowing dramatically the field of what's possible, the ways in which courts might go off in the wrong direction. And that's a virtue if you think that that's the proper way to interpret the Constitution. But the second problem of originalism is that understanding of limiting the meaning of the provisions of the Constitution to only those things that the framers themselves presumably affirmatively intended to hold unconstitutional is completely incompatible with the understanding of the framers of those very provisions. And therefore, it's completely self-contradictory as a theory of originalism. That is, the men who drafted the Bill of Rights, for example, and they were all men, were men of the Enlightenment. They did not think that when they drafted the open-ended provisions of cruel and unusual punishment and freedom of speech and freedom of religion and establishment clause and due process and the like, that they were adopting specific, narrow, concrete rules based upon what they, in their world, understood these terms, which were pretty foreign to them, really, to mean. They believed that knowledge grows over time. They believed that with experience and with changing circumstances, the meaning of concepts has to change. This was at the core of their spirit as men of the Enlightenment. And if you'd gone back and asked them, should we interpret these provisions to be limited to only those expectations you now have as to what they would mean, there's no doubt that their answer would be, what are you, crazy? That's not how law works. They were familiar with the common law. They did not believe that their immediate expectations were controlling. Indeed, they knew they didn't even have immediate expectations most of the time. So the problem with this advantage of originalism is that it's, first of all, completely contradictory to the premises of originalism, which is we should do what the framers want us to do. And the framers would not have wanted us to do originalism as the modern-day originalists understand it. And second of all, it flies in the face of what the framers, in fact, would have wanted, which is, in reality, a much broader understanding of what these provisions mean. As John Marshall said, right, it is a constitution we are expounding, right? It is meant to be able to be flexible and to grow and to deal with exigencies. So originalism then proves to be problematic, indeed, I think disqualifyingly problematic, even though well-intentioned, on both of these grounds. It's too vague when there is history, and even when the history is clear, the application of that history by originalists is another form of abdication of responsibility, and for that reason not acceptable. It's just another form of automatic judicial restraint which surrenders a power and a responsibility that the courts were meant to have. But that still leaves the question, if judicial restraint across the boards, although it has the virtue of neutrality, is not acceptable because of the fact that it abdicates responsibility, and if originalism is unacceptable for deciding when courts should be activist and when they should be restrained, for the reasons I've given, The question then remains, when should courts be activist and when should they be restrained? How should they know when it's appropriate to second guess in a serious and aggressive way the judgments of the elected branches, and how do they know when instead they should defer? So the best answer to this question, I think, goes back to Jefferson, Madison, and Hamilton, and others of their generation, who focused on judicial review and on the power and the need for courts to those situations where they were a corrective for majoritarian dysfunction. They believed democracy was the best system man had ever devised to govern himself, but they understood that it was imperfect. They understood and feared that majorities could behave in ways that were intolerant, that were self-interested, that were bigoted, that were hysterical, that were unfair. And the question was how to avoid that. Well, the checks and balances and separation of powers was one way to avoid that. But even that was imperfect, because there would be circumstances, certainly, where all the branches of the government would be controlled by a particular faction or political party. And the question then is, well, how do you check that? Well, courts were kind of a last resort. Courts were a way of checking that, in particular, with respect to guarantees in the Constitution, and in particular, when there was reason to believe that majorities were acting in ways that were outside the bounds of what was constitutionally appropriate. And so in Caroline Products, in footnote 4, Chief Justice Stone, no relation, I think well identified the circumstances in which, given that understanding of why we need courts, why we can't rely on majorities to interpret the Constitution, he identified essentially two critical circumstances where courts were necessary, and therefore they should engage in a much more activist approach to applying the Constitution. The first were those situations in which a law disadvantaged a group in society that had traditionally been disadvantaged and had been disadvantaged for reasons that seemed tied to indifference towards the fate of those people, bigotry, prejudice, and the like. Racial minorities, religious minorities, political dissenters, persons accused of crime, and so on. In that situation, you couldn't trust majorities, because we know from our own experience that they are likely to behave in ways that are suspect, and therefore you can't just defer. You can't just leave things to the ordinary workings of the democratic process and expect them over time to work out okay. And the second situation that Stone identified was that of capture. That one of the nightmares of a democratic process is the risk that at any particular moment in time, one faction or party or group will gain control of the levers of power. And if they do, they will manipulate the rules so as to perpetuate their own authority, if possible, indefinitely. And therefore, courts in that situation as well were necessary to step in and be suspect about those situations in which a majority may have enacted a law for the purpose of perpetuating their own authority. And when that situation arose, again, it was essential for courts not to rely upon the majoritarian process, which could be fixed, that is manipulated, fixed like a horse race is fixed. And courts needed to protect and guard against that. So those were essentially the two situations that Stone identified. And I think that wisdom still holds true. That if you start from scratch and say to yourself, okay, you're going to create a democracy in which majorities get to do what they want. but you're worried about majorities behaving badly. So badly that you don't want to leave it just to the democratic process. It seems to me those are the circumstances where you can identify dysfunction as a serious problem in society, as a systematic problem and danger, and that you need some external check, if possible, to restrain that. And that's when you need courts, most of all. And that's when activism is therefore most appropriate. Now, what's interesting about that is if you go back now to the Warren Court, and the Warren Court never endorsed footnote 4 of Carolyn Products as its centerpiece. But if you go back to the Warren Court and you lay out all of the decisions that the court made in those 15 years, and you divide them into two piles, activist and restrained, as best one can, what you will find is very interesting. What you'll find is that virtually every case that you put in the activist pile fits within the two principles of protecting groups and individuals who have historically been discriminated against and are not able to protect themselves against majoritarian prejudice, hostility, indifference systematically, or that are dealing with the problem of capture. So, the Warren Court decisions that were seen as most activist basically protect African Americans. They protect women. That actually came later than the Warren Court, but it's in the same basic spirit of it. They protect political dissenters, religious minorities. They require one person, one vote. They invalidate laws that limit the right to vote unequally. They invalidate laws that restrict freedom of speech and freedom of the press. And of course, they protect the rights of individuals accused of crime. Now, that doesn't mean each decision was right. One could argue about lots of the individual decisions of the Warren Court. But what it does say is that they were clearly acting out of an understanding or an instinct about when courts needed to intervene. And all the decisions that were in the restrained category don't fit into those two situations. So whether consciously or semi-consciously or just intuitively, what the Warren Court was doing was basically acting out of the sense that you need courts when there is a serious risk of majoritarian dysfunction. And that, I think, makes perfect sense for when activism is appropriate. Now, let me conclude by looking at the current court and the current situation. So the basic argument of the current conservative majority in the Supreme Court is captured by Chief Justice Roberts, right? Our job is to call balls and strikes, right? We are restrained, we are strict constructionists, we're generally passive, we stand in the shoes of the framers, we're originalists, we're the antithesis of activists. In fact, the justices, the conservative justices of the majority of the current Supreme Court have been remarkably activist in their jurisprudence. They have invalidated, for example, as you know, gun control legislation, laws limiting property owners' rights, laws regulating commercial advertising, laws limiting the power of corporations in the political process, laws regulating the power of the wealthy in the political process, and the like. Their jurisprudence, and affirmative action, I don't want to forget affirmative action, their jurisprudence, it's filled with judicial activism. Those are all cases in which the court is striking down laws enacted by the majoritarian political process on the claim that they are unconstitutional. At the same time, these justices routinely uphold laws that raise questions about the rights of persons accused of crime, of African Americans, of Hispanics, of gays, of women. So what's going on? Right? Basically, this court seems to move towards activism, aggressive constitutional scrutiny and interpretation, when the interests of corporations, of the wealthy, of property owners, of whites, of gun owners are at stake. And not when the rights of any of the people or groups who are most powerless in society are threatened. So clearly that approach can't remotely be squared with anything out of Carolyn products. That doesn't necessarily make it wrong. But in my view, it makes me wonder, well, what's going on then? How are they choosing the cases in which they choose to be activists versus those in which they choose to be restrained? And I've asked this question now. I've said to many of my conservative friends over time, okay, forget about what everybody says. Look at the decisions and explain to me what is the principle, what's the theory that explains the pattern of activism versus restraint in the hands of the current conservative majority. And interestingly, none of them has ever gotten back to me. Because the truth is, there's only one. And if you can come up with another, I want to hear it. But there's only one. It's the substitution of their personal political values for those of the elected branches of government, and using the power to interpret the Constitution to impose those values on the rest of society. They are doing exactly what conservatives accused the Warren Court of doing. But as we've seen, what the Warren Court was doing was actually following a theory of constitutional application and of the role of the court that does follow what I regard as a pretty legitimate and compelling principle. But you can't apply or discern any similar principle for the behavior of the current conservative activists. Now let me give you two examples, dramatic examples, I think, about what I mean by this kind of activism by conservatives, selective activism, both of which I came across in past years, long before I was thinking about this particular question. The first of them I came upon when I was thinking about Bush v. Gore. And when I was thinking about Bush v. Gore, I noted that Justices Rehnquist, Scalia, and Thomas all joined an opinion holding the Florida law unconstitutional under the Equal Protection Clause. Now, I happen to think that was a legitimate argument, given my view of the Equal Protection Clause. But I was a little bit surprised that Scalia, Thomas, and Rehnquist would adopt it. So I decided to look and see how had they voted on equal protection cases. So it turned out that they had voted in 59 cases raising questions under the Equal Protection Clause that did not involve affirmative action. Put affirmative action aside for the moment. In those 59 cases, they voted to invalidate the law 4% of the time. Their colleagues on the court, including some conservative justices, Nixon appointees, for example, as well as Ford appointees, voted 74% of the time in those same cases to invalidate the laws that were challenged under the Equal Protection Clause. Laws that were challenged by African Americans, Hispanics, women, gays, and the like. Okay, that could be judicial restraint, right? They're just really judicially restrained, which explains this enormous disparity between their interpretation and application of the Equal Protection Clause and everybody else's. But then it turns out, if you go back and look at the affirmative action cases, they cast 19 votes in cases challenging the constitutionality of affirmative action programs. Every one of them invalidated the laws that were challenged. Whereas the other justices, 62% of the time, voted to uphold the affirmative action programs. So basically, to these justices, the Equal Protection Clause means two things. Whites always win, and George Bush gets to be president. That's pretty problematic when you think about it. The second example, which I came across again independently of this, was after Chief Justice Rehnquist announced he was retiring. I was asked to write something about him, and I decided I'd take a look at his First Amendment jurisprudence. And I decided I like numbers, I like playing with numbers, even though I'm not an expert in that. And so I decided to try to figure out, what can we say about his jurisprudence of the First Amendment, free speech, free press, by how he has cast his vote over time. So it turns out Rehnquist voted in 260 cases involving the freedom of speech or freedom of the press that were not unanimously decided. The unanimous cases aren't interesting. In the 260 non-unanimous cases, he voted 8% of the time to invalidate the law that was challenged on grounds that it allegedly violated the freedom of speech or press. His colleagues, the other 8 colleagues in every one of these cases, voted 54% of the time to hold the laws unconstitutional. They were 7 times more likely than Rehnquist to vote to hold the law to violate freedom of speech or freedom of the press. Okay, again, that could mean Rehnquist is judicially restrained. He's passive. So then I looked at the cases that made up that 8%. When did Rehnquist vote to hold the law unconstitutional in violation of the free speech or press clause? Well, it turned out every single one of them fell within the following categories. They either involved restrictions on corporate expenditures in the political process. They involved limitations on expenditures or contributions by wealthy individuals in the political process. They involved limitations on religious expression. And they involved the right of the Boy Scouts to exclude gay scoutmasters as a violation of the First Amendment. That was the entirety. Oh, I forgot one. He voted to hold commercial advertising regulations unconstitutional. That was the entirety of Rehnquist's jurisprudence in 35 years on the Supreme Court on the free speech, free press clause. The press never wins. Dissenters never win. People who want the opportunity to march, hand out leaflets, engage in other forms of demonstrations never win. The only ones who win are corporations, wealthy individuals, commercial advertisers, and the Boy Scouts and religion. So those are examples of what I would regard as completely unprincipled and indefensible exercises of constitutional authority. And yet, they pass in the public understanding as just calling balls and strikes, strict construction, judicial restraint. This is a dangerous mythology that whatever one thinks about constitutional law, we should understand what the actual jurisprudence of these justices has been. And the opportunity posed by the Affordable Care Act, of course, gives another opportunity for these justices to act in the same way. I'm an optimist. I predicted before the oral argument that the court would uphold the legislation by a vote of 7-2. This is clearly a situation where judicial restraint is appropriate. It's the approach the court has taken to the Commerce Clause for 75 years. After the oral argument, it's anybody's guess. This might be another example, like Citizens United and other cases, of a 5-4 decision in which the 5 conservatives acted in a highly aggressively activist manner in a way that's completely inconsistent with past jurisprudence in order to effectuate their own political values and outlook. So on that hopeful note, I will stop and happily take questions. Thank you. Yes?
In your discussion with Justice Scalia, you mentioned his response to your first objection to provisionalism. Did he have an opportunity to respond to your second objection?
He did have an opportunity, and he said in his inimical way, he and I were colleagues in Chicago for a long time, so we're friends. He responded, this was a public discussion, he responded in his inimical way, "That's ridiculous." That's it. Justice Scalia has always been known for ridicule when he doesn't have a good answer. That's true. So that's true. So the answer I would have given, by the way, I actually gave it, in fact, in this discussion, when he basically said that's nonsense. And I said, well, he said there's two, the reason that would be, only reason it would be nonsense is if you think that the framers didn't, in fact, have a more capacious and aspirational view of these constitutional provisions. And that, I think, is completely, you can't sustain that as an originalist. But I said, I'll give you a better answer, which I don't agree with, but it's a better answer. It would be that, okay, even if the framers wanted to do this, and even if I was an originalist, we shouldn't be absolute slaves to the framers. They, after all, didn't know how a democracy would evolve over 200 years. And they would have wanted their successors over the generations to be able to act in ways that were not slavish to their understandings and intentions. So it may be that, in fact, courts turn out to be more dangerous than the framers thought. And that given the power to interpret these provisions in a more flexible manner in light of what the judges claim to be changed circumstances and changing social attitudes and so on, that in reality what they're doing is acting illegitimately. And that judicial activism that goes beyond the specific narrowly defined expectations of the framers might have been what the framers intended, but it turns out it was a bad idea. And since they didn't write it in the Constitution as a command that we have to follow, basically we should then exercise the flexibility to say that turned out to be a mistake as an expectation on their part, and therefore we should back away from it in order to readjust in a better way the balance of authority within the branches of government. That would be the answer I would give if I were Scalia. And I have to say, if the conservative majority stays in place for another 50 years, and I was still around then, I might well think that was a pretty wise position. But I don't think historically it's a wise position. I think that the court exercising a muscular authority has in general been a force for good, consistent with what the framers would have wanted of our Constitution, rather than a force for bad. So I think I would disagree with the conclusion that it's in fact worked out badly, even though there are individual decisions that may be wrong. Yeah. Yes.
So I'm just wondering if you could talk a little bit about whether or not this principle is based on just the assumption that majoritarian, that American politics is in fact majoritarian. Because I feel like for a long time it has represented the interests of the wealthy, and even
unlike today.
Now, we're seeing, wealthy interests having more and more voice, and so whether or not checking majorities, checking the excesses of majorities seems like more like maybe the court needs to check the excesses of minorities, in the sense that they are the ones who are really having influence. Because I noticed, in the traditional listing of all of these different groups that need to be protected as discrete and insular minorities, the poor, they're not on that list.
Well, no, I think the poor, for technical doctrinal reasons, the court's reluctant to include the poor, but the spirit of that, I think, would include the poor. So if, for example, there were laws that expressly disadvantage the poor, poor people may not use the municipal swimming pool, I think the courts would invalidate that. Even if there was a rational justification, well, poor people don't watch their kids and they don't clean up after themselves, and even if you could document those things were reasonably true, the court would invalidate that in a minute. So we've never really had a case, except disparate impact cases, where the poor have been discriminated against in quite that way. But if there were such a case, I think they would quickly fall into that category. As to the wealthy, the nation has always had this notion, the framers certainly had this notion, that the leadership of the country would come from the elite, right? even though they believed in a limited form of democracy. You had to be a property owner, you couldn't be a woman, you couldn't be African American, obviously. Even within the confines of who could vote, which was much more limited, they truly believed that the elite would rule, right? That it was men like Washington and Jefferson and Adams and Monroe and Madison who would lead the country. And the idea of the unwashed common man having a dominant say in the political process was one they were very uncomfortable with. Now, they weren't prepared to make rules to prohibit that, right? But their assumption was that the unwashed common man would vote for people like them to run the country. And so it would work, it would be okay, right? So they were sort of the wealthy in that standpoint. They had name recognition in a world where that was the most important thing. In terms of controlling the wealthy, I mean, I happen to agree with you. And I think the economic system and the political system have gotten dangerously out of whack in terms of the long-term best interest of the nation. And that a meaningful part of that problem was brought about by the Supreme Court. Initially, in Buckley v. Valeo in 1976, when the court held that it was unconstitutional to limit expenditures by individuals, a decision which I thought was probably sensible, but which, given the changes in wealth distribution in the country in the 35 years since then, have made that a much greater problem. So in the world in which Buckley was decided, the distribution of wealth in the country wasn't anything like what it is today. And so, although wealthy people had more of an influence than maybe they should have at that time, they were deciding that case in an environment in which the consequences were much less than they have come to be. And then, of course, Citizens United compounds it dramatically by adding corporations for the first time to the list of institutions that can't be limited in their expenditures. So, yeah, I don't know what the solution to that is. I mean, for the Supreme Court to overrule Buckley and Citizens United seems to me not implausible in a counterfactual universe in which we have a different set of justices on the Supreme Court. Neither is going to happen with this particular court. And when I think ahead, it's hard kind of to imagine easily getting to a position where any Supreme Court would be able to overrule this. Let's assume, for example, that Barack Obama is reelected. And let's assume, for example, that one of the 5 conservative justices is hit by a bus. Not wishing this, but let's suppose it were to happen, because they're not going to resign or retire. So let's suppose one of them is hit by a bus. And Obama gets to appoint that replacement. Well, what you could be absolutely sure of is he will never be able to appoint even a Kagan or a Sotomayor, who are pretty moderate, right? He will not be able to appoint anyone who 40 members of the Senate believe would move the court to the left. So when I think about the scenario, my guess is the best that he could do was appoint someone who was a very talented lawyer, presumably lawyer, about whom we know nothing, who both sides can say it's a complete and total crapshoot, right? Someone who would have to be so devoid of speech that we would all be comfortable saying, we're just throwing it to the winds here, and it's 50-50 as to where it goes, and this will be the czar of the United States. Now, that doesn't mean that czar might not turn out like a Justice Stevens or a Justice Souter and gradually gravitate to a position which might lead that justice to want to overrule cases like Citizens United or Buckley v. Valeo. But it's 50% chance that they won't. So I think for the courts to do this is pretty difficult. There's a group called Amend Now, Move to Amend. There's a bunch of different groups that want to amend the Constitution to deal with this. And that's, of course, admirable, and I love the fact that they care enough to want to do this, but it's not going to happen, right? 2/3 of both houses of Congress are not going to approve a constitutional amendment to overrule Citizens United or Buckley v. Valeo or anything of the sort. So there's virtue in that effort because it leads to public attention and so on, but it's not going to happen as a constitutional amendment. Maybe the only way to bring some degree of sanity to that is by public financing. If, in fact, there's public financing of elections at a high enough level. So you mentioned Larry Lessig. Larry, who was a student of mine, he's a professor now at Harvard Law School, has called for public financing in a voucher scheme. It's a pretty common suggestion. The idea is that state government or federal government would give every citizen $50, which they could use to support different candidates for office. And if a candidate chooses to accept that, they can't accept or spend any additional money. That's the deal. Up till now, the Supreme Court has said that would be constitutional. You can essentially subsidize an election, and the candidate can agree to take the money. Now, the only way that'll work is if the money they could get is greater than the money they could otherwise get. Right? So it means you'd have to give a lot of money. You'd have to inject a lot of government tax money into the political process to the point where it wouldn't make sense to be a free agent because you couldn't actually raise enough money from private individuals and corporations to match, let alone exceed, or vastly exceed, the public funding. That would actually be a scheme that would work. And, but again, the problem is getting it enacted. It only requires, well, in states, majorities, but in the federal government, it still requires a filibuster-proof bill. So that's a big problem. I think that's a really big problem. Citizens United, I think, at the time it was decided, by the way, I thought it was a reasonable decision. And I don't know how I would have come out, because it's a capture problem. Citizens United falls within one of the two categories that judicial activism is appropriate for. And when the government regulates the process by which individuals are elected, you have to be very nervous about what's really going on. Because there's a very strong probability that what they're doing is perpetuating themselves in office by manipulating the system. So clearly strict scrutiny, or whatever phrase one wants to use, is appropriate in that kind of a context. At the time of Citizens United, I actually wasn't persuaded, and I think I was rightly not persuaded, that the danger was great enough to satisfy the burden that the government should have in order to give the elected officials the power to make rules like that. Only 2 years later, now that we have a better sense of what's happened in those 2 years, I think that I would be satisfied today that the need for this regulation is sufficiently clear that such a regulation would be justified. But I don't think that it was an easy case, in fact, at the time. When do you want me to stop?
So let's have, one or two more questions.
Okay.
So I guess I want to follow up on your answer, which is, you said you're sort of an optimist. What's your experience been to people who are conservatives, originalists, after hearing you talk? You sound very pessimistic in the last answer you gave. And I guess my view is sort of, based on that, how we're going to approach cognition, people who have certain views are not necessarily persuaded by even logically an argument. They're going to say, that's ridiculous.
Right.
Or something like that. But that's sort of very, not really sad, but it's like what we should do in response to that, I guess. So that was what your thoughts.
I've tried to sit down with some of my conservative friends, including, I was chair of the National Board of the American Constitutional Society last year. And the American Constitutional Society is sort of the liberal version of the Federalist Society. And I tried to get people in the Federalist Society to sit down jointly with the national ACS people and try to have this conversation and recognize that, is there any way to come up with a jointly acceptable understanding of how we construe the Constitution? They didn't even want to talk. They refused to talk. I mean, the Federalist Society will have events with ACS all the time, but they wouldn't actually sit down and try to think through this problem. And I was appalled by that and disappointed by it. Is it possible to do that? Maybe, but it would be a great exercise, frankly. But so far I haven't seen anybody succeed in getting people at the table to do that. Yes?
With regard to your points on public funding of elections, would that really solve very much, in as much as what we're seeing now are large expenditures by independent committees, which may or may not have more influence than the actual candidate's expenditures. So would you have to address that as well, and is that addressable within our Constitution?
You couldn't address it under a current constitutional law. What you'd have to do is have so much money coming through the public system that it wouldn't make a difference. So $50 a person, if you add it up for the United States, is a lot of money, right? And in that environment, giving out a couple of $1 million as a private citizen isn't going to change anything.
You'd have to have enough money
To drown everything else out.
They could make his or her claim in the case, plus overwhelm all the private money in the United States.
Exactly. Exactly. That's what it would take. Right. It takes a lot of money. It takes a lot of money. One more question. I'm good. Yeah. Yes.
In reading the news coverage of the oral arguments regarding the Affordable Care Act, I've had a really hard time discerning what is the constitutional argument against the Affordable Care Act. I've heard a slippery slope argument regarding broccoli. I've heard them argue the merits of the health care law, which I don't think is really the issue. What is the constitutional argument?
Well, to be honest, I didn't think there was one. My view is that when the Affordable Care Act was enacted, if you convened a group of 50 law professors, 50 lawyers, and 50 law students, and asked all of them to, not group, a total of 150 people of those three groups, and asked them, is this law constitutional or not? My guess is that 98% of them would have said, of course it's constitutional. It fits within the jurisprudence of the Commerce Clause, and unless one wants to dramatically change that jurisprudence, of course it's not even hard. It's obviously constitutional. And then this argument was developed about the individual mandate being a requirement on individuals to do something even though they themselves are not engaged in commerce with respect to healthcare.
But do we not compel people to buy social insurance in the form of Social Security or Medicare?
And we require them to serve African Americans. We do all sorts of things that require people to do things they don't want to do. But normally they're engaged in some form of commerce. Social Security taxes. The tax power is different from the commerce power.
Also, are we really compelling people to buy insurance? Aren't we really just imposing upon them a tax if they don't buy insurance?
Well,
in which they get a pass?
it's a penalty. It's not a tax. I understand this is silly. I understand this is silly. That's why I thought the vote would be 7-2, and it should have been 9-0. But I figured that probably Alito, not even Scalia, I thought Alito and Thomas were a lost cause. But so I agree with you. I think there is no straight-faced argument that is plausible to invalidate this law. Doesn't mean it's good policy, doesn't mean it's a good law, but I don't see any reasonable argument for why it should be thought to be unconstitutional. Not in terms of precedent, and not in terms of my sense of when judicial activism is appropriate. And we'll see what happens. It may be that it'll be a 7-2 decision. It may be unanimous. I don't know. I wouldn't read too much into the oral arguments. I mean, the fact is the media has gone nuts. And the court itself turned this into a circus. I mean, why they did that, I have no idea. 3 days of argument. This was just ridiculous, frankly. And I can't imagine why they chose to treat the case the way they did in that respect. But in any event, then the attention that got paid to the oral argument is reading tea leaves in ways that are not necessarily realistic. Having said that, though, and listened to the argument, at least parts of it, there's different ways of asking questions. Right? You can ask a lawyer questions in which it seems hostile to the lawyer. But what you're doing is trying to explore whether there are problems in that argument. And you want to get the lawyer to help you figure out how to answer the problems that you see in the argument. And you might vote with that lawyer, and you might even intend to vote with that lawyer, but you want to test the argument to make sure that you've got it straight and that you understand the implications and so on, even though the question may sound, if you read it, may sound hostile. But the questions by Scalia, Roberts, and Kennedy, in particular, the tenor of them was hostile in a real sense. And that really surprised me. That took me aback. And that I think you can maybe read. But then again, this 4 months before they decide the case, they'll have plenty of time to sit around and search their souls and Unfortunately, they did that in Citizens United too, and they came out where they did. So, I would have thought that Citizens United was a case where the outcome was equally certain, given the fact that 6 years earlier the court had upheld exactly the same statute. So it speaks a lot about the court that Citizens United. Forget about the politics of Citizens United. The fact that they were overruling a decision 6 years earlier without any justification that is ordinarily accepted for overruling a prior decision, except for the fact that Alito had replaced O'Connor. I mean, that tells you something about the commitment to process and respect for the process.
So after the case, we'll have to have you back to come talk about it. Thank you so much.
Thank you. Thank you for having me.
So I hope you all join us for a reception next door where we can welcome Jeff and have a chance to visit. So thank you very much.